Hi, everybody. We're going to go ahead and get started. Hello and welcome to the Human Rights Webinar for Legal Aid with a focus on disability rights. My name is Lauren Bartlett. I'm the local Human Rights Lawyering Project Director here at the Center for Human Rights and Humanitarian Law at American University Washington College of Law. This webinar was organized as part of the local Human Rights Lawyering Project. The project aims to normalize human rights at the local level here in the United States. We provide training, resources, and ongoing coaching to legal aid and public defenders to use human rights to advocate for U.S. adherence to human rights standards as well as expanded protections for the most vulnerable persons in the United States. Today's webinar is part of our regular free webinar series aimed to introduce legal aid attorneys to our Human Rights in the U.S. Handbook. So really important is that our handbook, which the presentation will be today based on the Disability Rights chapter, is available for download on our website. Our website is wclcenterforhr.org. I also put a copy to the form in the little chat box, which you can find on your GoToMeeting webinar dashboard screen. It's one of the tabs. So that if you click on that link, it'll bring you to a form that you fill out, and it'll let you download the handbook. And we'll be going through the disability rights chapter today, so I suggest that you do that before we go ahead and get started if you have not already. I also wanted to give you an idea of some of the other trainings that are occurring this summer. We're organizing an in-person training for legal aid in Southern California at UC Irvine on July 18th, and another in-person training for legal aid at Miami at the University of Miami on August 16th and 17th. And then on August 23rd, we'll be holding another free webinar, this time on issues related to immigrants' rights. Information about all these trainings is available on our website, again, wclcenterforhr.org. And just a little technical issue. Right now, we have everybody in listening mode, but that doesn't mean if you can't communicate with us. I will be monitoring the question in the chat box throughout the webinar, so if you have any technical difficulties, if you have trouble hearing, please let me know. Also, if you have any questions, go ahead and type your questions into the question box, and I will ask the questions to Professor Dinerstein at the end of the call. There's going to be quite a few people on this call. We have almost 100 registered, so that's why we're doing it this way, just since we don't have too much time. Now, on to today's speaker. We're very pleased to have with us today Washington College of Law Professor Robert Dinerstein. Professor Dinerstein specializes in the fields of clinical education and disability law, the Americans with Disabilities Act, Civil Rights of Institutionalized Persons Act, the UN Convention on the Rights of Persons with Disabilities, legal representation of clients with mental disabilities, and disability and international human rights. In 2005, Professor Dinerstein founded the Disability Rights Law Clinic here at the Washington College of Law and has served as its director ever since. The Disability Rights Law Clinic was one of the first in the country to focus on both general anti-discrimination and special education issues on behalf of persons with disabilities. Professor Dinerstein has also served as the director of the law school's clinical program between 1988 and 1996, and then again starting in 2008. He was appointed by President Bill Clinton to the President's Committee on Mental Retardation from 1994 to 2001. Internationally, he's consulted for the World Health Organization in Ghana and Malawi, and the Open Society Foundations in Ghana regarding the revision of mental health laws, and was a signatory to the Montreal Declaration on Intellectual Disabilities adopted in Montreal, Canada in October 2004. He has also consulted with the Open Society Foundations regarding disability rights clinics in Latin America and Africa. Domestically, he has consulted with the Ford Foundation, Public Welfare Foundation, and the U.S. Department of Health and Human Services, and the U.S. Department of Education on issues related to legal services, disability law, and poverty law. With the Center for Human Rights Executive Director, Hadar Harris, he is co-principal investigator for our Disability and Human Rights Fellows Program, which receives support from the Open Society Foundations as well. Lastly, Professor Dinerstein has just been selected by the ABA Commission on Disability Rights to receive the prestigious 2013 Paul G. Hearn Award for Disability Rights, an award which is given annually to an individual or an organization that has performed exemplary service in furthering the rights, dignity, and the access to justice for people with disabilities. Thank you so much, Professor Dinerstein, for presenting today.
Thank you, Lauren, and thank you all for, in this odd format of where I can't see you all, but I look forward to the presentation. And I do want to reinforce what Lauren said about any questions that you might have. I'll try to answer them the best that I can. So let's begin. If I can get this going correctly. Okay. Up. All right. Start again. Okay. So we want to talk today about really the connection with disability rights as human rights and how they might relate to what you may be more familiar with, which is disability rights as civil rights. There's really a lot of, and to the extent that what we talk about today is helpful to you, I think a lot of ways it's going to be reinforcing of things that you may already be doing or knowing about through U.S. domestic law. But I think there's some interesting places where those laws diverge and where human rights framework may be helpful. The disability framework or the human rights framework in which disability exists is something which I think will be familiar to many of you, and that is that we think of disability not as a problem that is located within a particular person, but rather as the interaction between an individual and his or her environment. That could be a physical environment, or it could be an attitudinal environment. That is, the individual may or may not have a physical or mental impairment, but whether that impairment limits him or her in doing, in participating in society really depends on societal attitudes and structures, and that's really the primary focus of human rights law now with respect to people with disabilities. It wasn't always this way, and again, it wasn't always this way in the States either. The traditional model, there were older models even before the so-called medical model, models of religious views of disability, where disability was seen as evil possession, for example, or sometimes the source of particular insight. But in more modern times, disability was very much seen as a medical issue, or part of what's called the medical model. And again, this is probably something that you're all relatively familiar with. It is important, though, for you to know that at the international level, at the human rights level, the medical model has really been rejected, and that individuals who work in this world are very comfortable now with not the medical model, but rather with what's variously called the human rights model, or the social model of disability, or again in the States we might call the civil rights model of disability. That's very important when it comes to thinking about various legal strategies one might use, where the issue may be less a question of whether a particular institution is designed to accommodate a person with disability, but rather looks to see the relationship between that institution and the individual to see whether or not there's some opportunity to
Professor Dinerstein, sorry to interrupt you 1 second. If you can just hit the show my screen button, we're not seeing your PowerPoint. I think
okay.
Just on the dashboard, with the triangle.
Show my screen. How's that?
There we go. Perfect.
Okay.
Thank you.
All right. So we haven't gotten very far yet, so you haven't missed anything. Okay. And I'm going to talk quite a bit about the Convention on the Rights of Persons with Disabilities, the CRPD. And it is important to understand that the CRPD reflects this kind of social model, human rights model of disability, and what many individuals refer to as the paradigm shift, drawing on the term that Thomas Kuhn used many years ago in his writing, and that has now become almost a standard thing for folks to say. Okay, so let's see. So the CRPD, it actually had a remarkably quick development. It is remarkably quick for actions of the United Nations or at the international level. It was proposed in December of 2001 as a human rights treaty. It had a number of sessions that, drafting sessions that occurred over the course of approximately 5 years. And those sessions were extremely participatory, not only on the part of governments, but importantly, by non-governmental organizations or NGOs, which were groups of people with disabilities themselves, other groups that were advocates for people with disabilities. This is probably the most inclusive drafting process, I think, that a UN treaty had ever gone through. And in December of 2006, the General Assembly adopted the CRPD. It was then open for signature and became effective after a month after the 20th state ratified it, and that was on May 3rd, 2008. I always remember that because my birthday is May 3rd. I always sort of feel like, therefore, the CRPD is kind of related to me in some way. The CRPD is something which, if you go to many, many countries around the world and talk about disability, this is going to be the first thing that comes to people's mind, and that's because 155 countries, as of today, have signed the CRPD, and 132 countries have ratified it, which is a rather remarkable record, and one that, again, in UN terms, really is quite good, given that it's only really been open for signature for about 6+ years. The most recent country last week was Palau, that ratified the convention on June 11th. There's also something we're not going to talk about much today, but just so you know, there's a part of the convention called the optional protocol, which allows actually consideration of individual complaints that a person can bring before the Committee on the Rights of Persons with Disabilities, which meets in Geneva. And in that optional protocol, 91 countries have signed that. 77 have ratified it. I think it's quite fair to say that the U.S. will not sign, and therefore not ratify, the optional protocol. That would subject it to individual complaints, and it's not a process we are likely to engage in. At least when I last checked, the committee had issued one decision under the optional protocol. There may be more, but this was at least the one that I know about. Okay. Now, as you may know, the United States did not originally sign the CRPD. The CRPD was open for signature toward the end of the Bush administration. The administration took the position at that time that we did not need to sign the CRPD. And there really were two arguments that were made. They were kind of inconsistent with each other. One was that we already comply with the CRPD because we have the ADA, and I'll come back to that a little bit later. And then the second argument, inconsistent with it actually, was the U.S. doesn't sign any convention until it knows it's actually complying with every provision, and since we couldn't say that yet, we therefore shouldn't be signing. Now, again, if that were the standard, I don't think any country would sign the CRPD or any treaty, really. And as I said, there was a sort of internal inconsistency with that argument. Nevertheless, during this period, officials from the State Department and Department of Justice were very active and very helpful to individuals who are participating on behalf of their countries or the NGOs to give content to the CRPD. So in the kind of interesting way in which these things can operate, even though the U.S. was not involved per se, it was able to play a role, which was an important role in the drafting of the convention. When President Obama came into office, actually as part of his campaign, he vowed to sign the CRPD. He did so, and that signature was communicated to the United Nations on July 30th, 2009. So about 4 years ago, this July. After the signature, the federal government then went about the process of putting together what's known as the ratification package. As you know, the Senate, any treaty in the United States has to be ratified by 2/3 of the Senate. or 67 votes, that the ratification package entails the State Department really getting buy-in and information from, I think, about 12 or 13 different federal agencies to kind of put together their take on how U.S. law fit or didn't fit with the CRPD. Also very important at that point, the U.S. submitted its information to the Senate Foreign Relations Committee. This was in May of 2012. And in that submission did not propose any limitations that were specific to this convention through what are called RUDs, or reservations, understandings, or declarations, which can be ways to limit the effect of a treaty. There were some RUDs, there are some standard RUDs that the United States has, but at that point there were not ones that were specific to the convention, which was interesting and not at all a certainty that that would be the case. The package, basically like a proposed legislation, got submitted to the Senate. The Senate Foreign Relations Committee has held hearings last summer. Senator Kerry was then the chair of the committee, and the committee added a few RUDs, in a sense clarifying for the Senate what the treaty might mean. And the Senate reported out favorably, the committee reported favorably to the Senate the treaty. The treaty then came up in the lame duck session for consideration by the Senate. Again, if you followed this, as I'm sure many of you did, it looked like, as of the weekend before the vote came up, that it was going to pass. In fact, it wouldn't have been brought up if the leadership of the Democrats didn't think it would pass. And in the end, however, really at the very last minute, pretty much the weekend before the convention came up for a vote, there was a very strong lobbying effort with the result that the treaty did not get ratified. It passed, but with 61 votes instead of the 67 that were needed. There's some view that probably it could have gotten at least 3 or 4 more votes because some people wound up not voting for it once they saw the way things were going. But in the end, it was very clear that they were a few votes short. You may remember one of the things that was done was that Bob Dole was actually came onto the Senate floor to express his support for the convention. He's been a longtime supporter of the rights of people with disabilities. And even though a number of senators went over to pay their respects, that did not affect or did not cause them to vote for the treaty. On my next slide, I put that the issues that derail the ratification, I put it in quotes because I think it's some of these issues really seemed, I think to many of us, to be rather ludicrous, but they were presented. And one of the big ones was supposedly that the treaty would put in jeopardy parents who wanted to homeschool their children with disabilities and would prevent them from doing so because the convention said that children with disabilities were entitled to application of the best interest of the child standard. I don't think many of us thought that was really a serious objection. The convention in no way talks about the right to homeschool. There were definitely opinions expressed that that was the case. Nevertheless, there were, I think, a number of people who became convinced by former Senator Rick Santorum and others that this was a real risk and that this treaty, if passed, would somehow put in jeopardy their right to control their children's education. I would point out, and I'm sure many of you know, the standard of best interest of the child is a very common standard in state law in the United States with respect to many issues regarding children. And any parent in the United States, of course, while having a lot of authority over his or her child, doesn't have complete authority, including if they abuse or neglect their children. So I think there was a fair belief that there really was no new law being created here, but it was presented as a possible problem. There's also, of course, with respect particularly to human rights treaties, a sense that that is, the argument is made that the United States doesn't want or need anyone else telling us what to do. The UN, we don't want the UN coming in and dictating to us what our role ought to be. I think most people, again, understand that's not really what happens, but it managed to perhaps strike a chord with some, at least. In any event, the treaty, the ratification failed. Surprisingly, I think to me and maybe others, a lot of people who thought this was almost a no-brainer that it would be ratified were quite taken aback. And I guess the true test of how this was perceived was that it made it onto both the Daily Show and the Colbert Report as an indication of just how unable the Senate is to do even some very basic things. So there were, again, all the Democrats voted for it, and most Republicans did not. There were some Republicans who crossed over, John McCain and some others, but not enough. It is going to, the fact that the ratification failed doesn't mean the treaty is dead for all time. It does mean, though, it has to be reintroduced. It has to go back to the Senate Foreign Relations Committee. As you know, John Kerry is no longer in the Senate. He's Secretary of State, so there's now a new head of that committee. I think it's Bob Menendez from New Jersey. I think the feeling is that at least that it will go back to the Senate, and that there have been a lot of folks working on making sure that happens. Nothing's going to happen until immigration reform gets addressed, and probably after that some other kinds of things. So I'm not particularly good at prognosticating when this might happen, but it will happen at some point. So that's a very kind of quick run through as to what happened at the convention. You should understand, and those of you who have some human rights background will know this, that in the United States, treaties such as the CRPD are not self-executing, which is that although they will be the law of the land, you will not be able to go into court if it is ratified and sort of cite directly to the CRPD as dispositive. Rather, you would need implementing legislation, putting that into effect, or multiple pieces of legislation to make that happen. Nevertheless, if the treaty is ratified, I want to say when, but I will say if, and in conjunction even with its existence now as a signed treaty, it does have a lot of effect, potential use as persuasive authority that courts can look to. And so that's really a lot of the ways in which I think it's going to be helpful to you, or could be helpful to you in your work. Okay, so that's a lot about the process of the CRPD. What about its content? What does it say, and how might it be useful to you in your work? The first important thing to say is that the CRPD places a broad emphasis on issues of individual autonomy, dignity, and equality. These are, again, rights that are quite consistent with our own view of rights of people with disabilities and others. It very much fits into that mode. That is, we are past the point not only of the medical model that I was describing earlier, but also of viewing disability as tragedy, viewing disability as something that people must be helped with but not respected for. And I think that's an important way of thinking about this treaty as a rights treaty and not as a charity treaty. Interestingly, the treaty does not actually define disability, and those of you with 504 and ADA background know how much blood has been spilled to try to get at just what it is, or how one defines disability under those statutes. What the CRP does do is it gives some overall guidelines to countries as to how to define disability, but leaves it to the countries as to what those definitions would be. So what the CRPD says itself is that it defines persons with disabilities as, quote, those who have long-term physical, mental, intellectual, or sensory impairments which, in interaction with various barriers, may hinder their full and effective participation in society on an equal basis with others. That's from Article 1. So what you see in that is a definition that specifically and explicitly refers to the interactive part of the discrimination as being key, that it's not just the impairment, it's the impairment plus the barriers that exist. So that's a very important element of the convention, and I think one that makes it, again, quite useful to us. The discrimination on the basis of disability is defined. Again, not the disability itself is not, but discrimination is. And that definition appears in Article 2. And it is described as any distinction, exclusion, or restriction on the basis of disability, which has the purpose or effect of impairing or nullifying the recognition, enjoyment, or exercise on an equal basis with others of all human rights and fundamental freedoms in the political, economic, social, cultural, civil, or any other field. It includes all forms of discrimination, including denial of reasonable accommodation. So what we have there is, again, a very broad sense of what amounts to discrimination. As the ADA and 504 do, it specifically references the failure to provide a reasonable accommodation as a form of discrimination. That's obviously important in any work that might be done. And it also, of course, gives you a sense of the broad reach of the different kinds of rights that are implicated, could be implicated in some form of discrimination. And then I would say, too, by talking about discrimination, which has the purpose or effect, it also does get past intentional discrimination and goes beyond that. Now, if you had listened to any of the debate about the CRPD, or just randomly heard people talking about it, you heard a lot of people saying, including supporters, that of course we ought to ratify the CRPD because it's really just the ADA internationalized. And some of the arguments were, if we want United States citizens who are traveling abroad to be able to benefit from, have access to various buildings and other parts of society, the CRPD would be important for that. That is true, I believe. But it is, I think, a little misleading to say that the CRPD is something like an international ADA. And that's for a variety of reasons, some of which I will cover. I think the main thing to say about that is that, for one thing, the CRPD doesn't have the sort of federalism structure, and doesn't have the distinction between what's a federal right and what's a state or local right. As a consequence, addresses issues, some issues that wouldn't be addressed at the federal level in the United States. So, for example, Article 12, which I will be talking about in a moment, which addresses issues of guardianship, or at least is interpreted to do so. Guardianship is not a federal right, or the issues around guardianship don't exist at the federal level in the United States. They exist at the state level. And even though many state statutes are similar, it is a function of state law. And so that's something where you wouldn't find a U.S. guardianship law. That's also true for Article 14, which is the article on deprivation of liberty, or liberty and security of the person. That would be more or less equivalent to a civil commitment statute, or among other aspects would include that. And that, again, as many of you know, is primarily a function of state law. Article 23, which talks about rights of individuals in the family. Again, these are areas, and there are others, which primarily for us are issues of state law and would not be primarily, at least, an issue that would come up in the ADA. The CRPD also covers some things which are not a matter of state law or federal law, at least in the way the CRPD talks about them. And some of these are rights that we've been advocating for in different contexts with more or less success. Right to personal mobility under Article 20, right to an adequate standard of living under Article 28, the right to participate in cultural life, Article 30. These are rights that at least would not, might be able to be constructed through a series of arguments, but don't come out in that kind of stark way that the CRPD covers it. CRPD, in addition to talking about the rights of people with disabilities generally, has specific articles that address the rights of the particular rights of women with disabilities in Article 6, children with disabilities in Article 7. It addresses broad areas of societal participation, including education under Article 24, health, Article 25, work and employment under Article 27. So the convention has a number of really interesting and important provisions, and I'll come back to some of them. I'm just highlighting a few of them. Actually, I meant to say, and I will go back just for a second to say this, that once, and again, if it's the case once as opposed to if, but once the U.S. ratifies, one of the things that happens is, first of all, it becomes possible for a representative of the United States to be a member of the Committee on the Rights of Persons with Disabilities. He or she would have to be elected, but that would give the U.S. Representation on that body, which is important. It would also allow the United States to participate in what's called the Conference of States Parties, which meets at the UN in New York periodically to talk about, again, issues that might arise under the convention. As of now, we can be observers but not participants. We will be required at some point, if we do ratify, to submit a report to the committee, which will identify the extent to which we believe we are complying with the various articles. And at that time as well, there'll be an opportunity for community organizations, NGOs, to submit their own version of the U.S. compliance. So that's an important role for many organizations or potential organizations to play to challenge, perhaps, the administration's view of just how well they're doing in meeting the standards. And then the U.S. will have to appear at some point before the committee in Geneva to make its case, to receive questions, and ultimately there will be issued what are called concluding observations by the committee that the U.S. will need to respond to. But there's no, again, jackbooted United Nations police who will come in and somehow confiscate our property or our rights because of this. It's part of a very different kind of dialogic process. Okay, so some of the key provisions of the CRPD, and one of the ones that I have focused on a lot, and I think might come up for many of you in the context of representation you might be engaged in, is Article 12. Article 12 is called Equal Recognition Before the Law, which by itself may not tell you much, but it is a key provision because of its focus on legal capacity. Subsection 1 of Article 12 says that states parties reaffirm that persons with disabilities have the right to recognition everywhere as persons before the law. Paragraph 2 says that states parties shall recognize that persons with disabilities enjoy legal capacity on an equal basis with others in all aspects of life. And 3, states parties shall take appropriate measures to provide access by persons with disabilities to the support they may require in exercising their legal capacity. Taken together, these and the remaining paragraphs of this article establish that everybody is not only presumed to have capacity to act and to have rights, but that presumption may not be overcome. That's important because in looking at U.S. Statutory law, there's definitely a question as to whether our guardianship statutes would comply with Article 12, at least as those are written. There have been different interpretations of what level of whether guardianship can survive at all under Article 12. Some countries, Australia and Canada, which have been very active in challenging guardianship, have actually issued either reservations or declarations that their understanding is that limited guardianship might be permissible under Article 12, even if general or plenary guardianship is not. That is certainly one way to interpret the provisions of Article 12. But that provision in the third paragraph about support is a very important one because, as I'll come to in a minute, that provision has enabled people to argue that what individuals need who need assistance in making decisions or implementing decisions, what they need is not a substitute, but rather support. They need an individual, groups of individuals, preferably people who know them, who can help them engage in all the kinds of decision-making that adults do, deciding who to marry, deciding whether to buy a home, deciding to open up a bank account, etc. Some of them may do that without any assistance, even though they have a disability, because they understand those decisions and can articulate them and implement them and communicate them. Others perhaps need some help in doing so, but they don't necessarily need somebody to stand in their shoes as a guardian and take away all their rights. So that's a very key provision. It's gotten a lot of attention in various quarters internationally and increasingly actually even domestically. Article 14, liberty and security of the person, is an interesting one because it says that state parties shall ensure, among other things, that people with disabilities are not deprived of their liberty unlawfully or arbitrarily, and that any deprivation of liberty is in conformity with the law, and that the existence of a disability shall in no case justify a deprivation of liberty. This article, some have argued, would actually ban civil commitment in all cases. It certainly would suggest that civil commitment based simply on the existence of mental disability would be insufficient. It's not clear whether mental disability plus dangerousness, for example, would satisfy this provision. This is one that there's going to be a lot of interpretation, a lot of discussion about, and a lot of countries are struggling with how to interpret this provision. But it certainly suggests, and some would say that what it does is say you can't include disability at all. You should only be looking at people who engage in activities that could be subject to state control, whether they had a disability or not, which could mean the criminal justice system, for example. That's not the only possible interpretation, but it's certainly one that's out there. Article 19, living independently and being included in the community, is one that I think will ring familiar for any of you who work on Olmstead issues in the United States. That is the ADA case that talks about community integration under the statute. And it, too, emphasizes the important need for people to be integrated into their communities to not only live in the community, but be of the community and with whatever supports, both in-home and otherwise, that they might need. So whereas perhaps Article 14 would engage in a true change in U.S. law, Article 19 I would see as more supportive of other kinds of activities that people might engage in. And in the last one I mentioned on this slide, there could be others, but just Article 29 on participation in the political process or voting. I've learned, and I learned this somewhat personally because I have a sister with a disability for whom I'm the guardian, that the state laws really vary as to whether people under guardianship may or may not vote, that is including limited or plenary guardianships. And this is a provision I think that's going to get a lot of attention. There's been some beginning efforts to bring cases on it. But people who may need some reasonable accommodation to vote, may need some assistance, but that could be anything, could be something as simple as plain language statements of what the choices might be for them. And that's something where I think we're going to see some activity. Okay, so I entitled this slide "Creative Uses of the CRPD" because there have been, well, one judge at least, Kristen Glenn, who's a surrogate judge, was a surrogate judge in New York State, has been using the CRPD or mentioning the CRPD in some of her decisions, actually 2 decisions in particular. Judge Glenn reached mandatory retirement as of the end of 2012, so she's now back agitating from the sidelines, if you will. But she issued 2 decisions, one in re Mark CH back in 2010, and the most recent one in re Damaris L issued December 31st, 2012. And in each of these cases, Judge Glenn addresses one of the New York State statutes on guardianship. It's Article 17A, which is for people with intellectual disabilities, as opposed to sort of the general guardianship statute, Article 81. And in those, she, in one case, uses the Article 12 of CRPD to support her view that a guardian must do periodic reporting on behalf of the individual for whom he or she is the guardian. That even though Article 17A didn't talk about that, that a periodic reporting requirement is necessary to give effect to the individual's constitutional rights in the U.S., but also to be consistent with Article 12, which she cites as what she calls, and what others have called, persuasive authority. That is not binding, but important information that has the can have the effect of customary international law. In the Damaris case, decided really in I think her last decision, she went further and terminated a guardianship, actually with the consent of the individuals who were performing, who were guardians. But in place of it, I argued quite explicitly for supported decision making for people with individuals with intellectual disabilities to really use that new paradigm of support instead of the substitution. As I said, Judge Glenn is was path-breaking, I think, in using and referring to Article 12 at this stage. I'm hoping, though, it won't be a one-off or a two-off on her case, and that others will have an opportunity to follow through, again, with state statutes that look pretty similar, even though they are a matter of state law. I mentioned on this slide here, she's written a law review article in 2012. I've also written on this topic for the Human Rights Brief. There's just a lot of activity right now on Article 12. And I should say that for those who think that she's way out there on sort of looking at international law, for those of you who go back a ways and have dealt with issues or aware about the landmark case of Wyatt versus Stickney from Alabama, Judge Frank Johnson, way back in 1972, actually referred to, in a footnote, to the Declaration on the Rights of Mentally Retarded Persons as supporting the very extensive court order that he entered back in that era. I actually worked on the Wyatt case not in 1972, and later in the 70s on one of the enforcement provisions. But you know, it's interesting that Judge Johnson thought that provided, again, a little bit of interesting support for that proposition. And of course, you probably also know that in the Atkins versus Virginia case, which said that people with intellectual disabilities could not be subject to the death penalty, that Justice Stevens made reference to international law as, again, supporting the court's view, or at least the majority's view, of that the death penalty can become cruel and unusual for these folks. So I think there are some opportunities here that don't have to seem like they are so out of line. Again, Article 14, which I've mentioned earlier, which could be used, again, in this kind of persuasive authority way to at least limit, if not altogether get rid of, coercive or involuntary treatment on the basis of mental disorder. Certainly could be raised, I think, with respect to those statutes that have added in a kind of grave disability or significant deterioration prong beyond the simple dangerousness to self or others. That's a much less developed area than Article 12 is, but I think it's certainly something that's potentially on the horizon. Article 19, right to live in the community. Again, I think I mentioned that as something that could be used at least as additional supportive authority to suggest, I think, that judgments that are being made about people with disabilities, that the U.S. is not like way off in terms of what the field is thinking about this. And that may be important when we look to issues like Olmsted-type issues, which relate, for example, to the role of guardians, because some of the leading human rights cases in the European system, the Stanev case, the Shapirov case, have been cases that have raised issues of guardians who have, quote, volunteered, unquote, their wards into facilities and then objected to any kind of release on their part, and then the individual being found by their own country's laws to be unable to actually challenge that because of the claim that they had no capacity. And the European Court of Human Rights has said, well, that can't be, that catch-22 isn't going to be given effect. And so I think, we might be facing some of those similar issues in some of the Olmsted litigation where guardians have purported to object to, for example, individuals being placed in community-based programs if the guardians have a problem with that. Okay. Now, I've been spending a lot of time on the CRPD. I think it's probably where most of the action is, but you should know there are other sources of human rights law that could be useful to you. One is the U.S. has actually ratified the Convention Against Torture. As it happens, the dean of my law school, Claudio Grossman, is the chair of the UN Committee Against Torture, so presides over those proceedings. And the special rapporteur on torture, who's also a colleague here, Juan Mendez, issued a report in February of this year in which he, as part of the Convention Against Torture, referred to some of the provisions that we've been talking about under the CRPD as being perhaps cruel, inhuman, or degrading treatment. Perhaps not arising to torture, but nevertheless being cruel and inhuman. And again, as I put on the slide, a predecessor of his said that solitary confinement for people with disabilities would be a violation of this convention. And Juan Mendez refers in several paragraphs in this report on limitations on solitary confinement, restraint, and coercive treatment as a matter of torture or inhuman treatment. So that's, I think, a kind of interesting possibility to use domestically. In fact, the Disability Rights International has made the argument that the practices of the Judge Rottenberg Center in Massachusetts, which many of you may know about is rather infamous, that the practices there of using aversive stimuli, aversive conditioning on people with children with disabilities amount to torture under the convention, and the special rapporteur has gone along with that. There are many other possibilities that could be used, I think, and we're really just beginning to see the advantages. One is, of course, increasingly we all depend on access to the internet, to other forms of communication that may open up various worlds for people with disabilities, but not if people with disabilities can't really get access to them. So Article 9 of the CRPD talks about accessibility, including to websites. As you know, that's an issue that under the ADA, many argue should be, that Title III of the ADA should apply to the internet. There's case law that goes both ways on that, but and in addition, under 504, federal agencies are required under 508 to be accessible. And of course, as you may know as well, there's a treaty now being negotiated in Geneva for print-disabled individuals. So there's lots of things that are going on there in terms of access to information. Article 24, inclusive education, I think is something that, again, consistent with IDEA and other U.S. statutes is something that can be supportive. Access to justice under Article 13, whether that's ability to serve as witnesses in proceedings, ability to serve on juries, ability to, or requirement that proceedings, that one be competent to understand proceedings against him or her, which the Handbook talks about in the immigration context. These are all situations where I think the CRPD can be useful. And I should say, when I say CRPD, in addition to the document itself, obviously the interpretations of it, both by academics and lawyers and otherwise, I think can be helpful as well. I do want to refer to the handbook, which Lauren mentioned at the very beginning of this webinar. It gives you, I think, some very interesting sample arguments that one could make. In one case on accessibility, website accessibility, and the other on possibility of getting a temporary protection order for a woman with a disability. And so I think one of the things that I hope will come out of this and other sessions like this is that people will be able to connect with each other on the possibility of some arguments one could make to persuade some judges to at least be thinking about these issues in kind of broader terms. And so in the end, my conclusion is that, excuse me, that human rights principles are very consistent with U.S. disability law, and as a consequence, I think, are just another tool in the toolbox that one can use. With some judges who may be particularly enamored or attentive to those issues, others certainly might be more skeptical. But I do think it's important when we look at these issues, and there's a lot of discussion these days about American exceptionalism and the extent to which we have procedures or rules in place that make us different from the rest of the world. I think this is an area where we can, in fact, both be proud of the way in which U.S. law, at least, excuse me, in which at least U.S. law on the books, whether or not it's U.S. law in operation is a different matter, but that U.S. law has been both important in its own right, but also important symbolically to lots of other countries that look to laws like the ADA, IDEA, related statutes, and think about developing their own national laws as well as seeing how the CRPD might be influence for them. So with that, I think we have a few minutes for questions if there are any. And Lauren, I guess I'll defer to you if any came through.
Yeah, so we don't have any questions yet, but if anybody has a question, if you want to just enter it into the question box, I'll go ahead and read it out to Professor Dinerstein. If you want to and you're on the phone, feel free to raise your hand and I can unmute you and you can ask your question orally also if that works better for you. But any questions regarding the presentation that was just made would be great. Also, for those of you asking about a copy of the PowerPoint presentation, I just put a link to our website in the chat box. If you go onto our website, and I'll put another link to the exact place where it is, but it's now available for download on our page on our resources page under upcoming human rights trainings, and then there's an entry for today, and the PowerPoint is available there for download. Let's see. Any questions beyond getting a copy of the PowerPoint?
Lauren, let me just add that I'm happy if anybody has a specific question, and after this webinar and wants to email me, you can certainly do that. My email is rdiners, R-D-I-N-E-R-S, at wcl.american.edu.
Great. And I'll put that into the chat box as well for everyone.
Great.
we'll give you all a couple more minutes, but if there are no questions right now, thank you so much, Professor. Oh, here we got a couple of questions coming in. Here's a question for you. How do you think U.S. courts would respond to using the CRPD in domestic cases?
Well, I think that to some extent it requires, well, obviously a certain amount of subtlety. I can certainly see many judges who I've appeared before who, as a judge in Maryland, said once to us when we cited Terry versus Ohio, well, we don't really follow Ohio law here in Maryland, which, of course, was U.S. Supreme Court law. So in the first instance, you want to be able to get a sense of whether or not you're before a court that might be sympathetic to this. But beyond that, I think it's available as as strong arguments, or can be strong arguments that can buttress the arguments that you make that are mostly going to be based on your substantive law. So, Judge, I very much would suggest looking at those decisions that are cited by Judge Glenn, because she does a nice job of referring to the CRPD in that guardianship context without saying that because the CRPD says X, that therefore the result ineluctably follows. It's not going to be quite that easy. But the fact that the arguments that are being made are supported by that, I think, is just one more, as I said, one more argument to make. I think more authoritative than, citing, again, a law review article or even a treatise because of the process that it went through. But in a particular case, it's very much going to depend on who your judge is and how you present the argument.
And a follow-up question for you would be, are there other ways besides in U.S. courts that you would suggest legal services attorneys use the CRPD in practice?
Well, one of the things that's kind of interesting, the CRPD has an article, Article 8, called Awareness Raising, and which it talks about that the state parties, again, this is what the countries are supposed to do, are to take measures that, among other things, combat stereotypes, prejudices, and harmful practices relating to persons with disabilities, including those based on sex and age, in all areas of life. And so I could imagine a situation where a legal services office, in doing a kind of Know Your Rights project or campaign, has some sessions perhaps linked to also letting people know about their rights domestically as well, just to say, here are some things that are happening, and you may think, ladies and gentlemen of our particular area, that what goes on here doesn't connect to the rest of the world, but you should know that it really does. And I think, going back to the whole ratification mess back from December, I was really struck by the fact that it wasn't just pointy-headed academics who were complaining about the failure of the Senate to ratify, but when it hits not social media, but when it hits media like Jon Stewart and Stephen Colbert, it tells you that some of these issues have a greater resonance. So just as the ADA, I think in theory and in symbol plays a role that's actually distinct from what it says specifically in content, I think the CRPD can do that as well. Great.
Well, that is all the questions we have. Oh, wait, hold on. So I have somebody's. We have one question from Rena. I'm going to go ahead and unmute you, Rena. Rena, you should be able to ask your question now. Rena? Oh, it says you're self-muted. She's having technical difficulties. Try this again. Well, Rita, if you want to just enter your question in the question box, for some reason it's not letting me unmute you completely. I'm doing everything I can on this side. So it looks like we have one other question. Anybody else have a question for us? Okay. We'll just give it a couple more minutes. Thank you again, Professor Dinerstein, so much for your presentation. I'm sure you'll get some additional questions. I just want to remind everyone that we'll be having another webinar in August. That one will be on immigrant rights, and there's a sign up on our website. This is Rena's question. She says she's wondering if there's a listserv for disability attorneys that use human rights. Do you know of any listservs, Professor?
You know, that's interesting. I don't that's specifically human rights focused. There's the Disability Rights Bar Association listserv, which mostly deals with, and some of you may be on that, it mostly deals with domestic issues. Every once in a while there'll be a question about an international issue, usually the CRPD, but not something which is the primary focus of those folks. There certainly are, I'd say, you know, a number of well-known international NGOs that deal with these issues. I mentioned Disability Rights International, which is located here in Washington. Another very active group, particularly on the issues of guardianship and capacity, is located in Budapest, Hungary, the Mental Disability Advocacy Center, or MDAC. Both of those organization websites, if you just put either DRI or MDAC, I'm sure you'll get to them, have a lot of information. But as far as a listserv, and maybe you know, Lauren, but I'm not aware of one, and it's not a bad idea, I think, to do that, because there have been a variety of different networks that are kind of maybe regionally oriented. So, for example, there's a Latin American network, or RED, of folks who are doing some disability-related work. And then we mentioned earlier this Disability Rights Fellows program that Hadar Harris and I co-direct here. That's a program that has 6 universities around the world that have some number of disability rights fellows, and we've been talking within that group also of trying to create a kind of network. One of the schools that's in that group is the Disability Center at Galway in Ireland, which is very active on a lot of these issues. But as a pure listserv, I'm not aware of one.
Yeah, so there's the Bringing Human Rights Home network, the Lawyers Network has a listserv for U.S. attorneys who use human rights in their advocacy here in the U.S., but it's not dedicated to disability rights. So yeah, we could consider creating one. I'll post the information about that listserv for those of you who are interested in the chat box as well. But it's Bringing Human Rights Home Lawyers Network, which has you know, a few times a week posts from people. It could be used a lot more than it is. We have one last question for you, Professor Dinerstein, to follow up on Rita's question. Are there other ways that you recommend, Professor, that we follow these issues?
Well, you know, I do think those 2 websites that I mentioned for DRI and MDAC are part of that. Also, the United States, many of you probably know the National Council on Disability. It has an international sort of cognate group called the U.S. Council on International Disabilities, U.S. ICD, and they are a good source of, again, things that are going on in the international side. They certainly are monitoring ratification progress. That would be a place too that I would suggest going to. And then if you just want to get a sense of how the Committee on the Rights of Persons with Disabilities is going, if you go to the UN Enable website, that's U, capital U, capital N, and then the word enable, all one word. That's a great location for, it's got the convention, it gives you which countries have signed and ratified, and in addition, a link to the committee. And you could actually go on and see, for example, gee, what did the committee do with regard to Spain or Argentina, and click on, you know, the session, and click on, you can see the concluding observations and the questions that were posed that I was referring to earlier. That's helpful for researchers, but in addition, I think it's helpful to see as litigants and as litigators, what it is that the committee is saying. For example, in looking at what the committee has said under Article 12 on equal recognition before the law, they have consistently said to the countries that they have posed concluding observations about that those countries' guardianship laws have to be re-examined. So that's something which is one place to look if you're just looking to get a sense of what they're saying.
And there's one other question, which is there something akin to the CRPD at the inter-American level?
Well, that's a great question for a couple of reasons. There actually was a treaty that preceded the CRPD. There is an inter-American treaty. It's by all accounts not as it doesn't provide as many rights and is not as useful as the CRPD. One of the things, though, that the Commission or that the treaty body recently did, like within the last year, was to say, well, we don't have in our treaty in the Americas anything that talks about legal capacity, but we, in the inter-American system, will look to the CRPD, and particularly Article 12, to inform the way we think about legal capacity in the Americas, which is a very big thing because a lot of the countries in the hemisphere have very outmoded guardianship laws or interdiction laws in which guardianship is plenary and people under guardianship are extremely limited in the rights that they have. So that the inter-American system would, in a sense, piggyback on the CRPD is a very good sign and an indication that the CRPD is playing a role that, again, is a kind of customary international law. So thank you for that question, because I think it is something. I also, for a variety of reasons, think that the Commission, the Inter-American Commission on Human Rights, and perhaps even the court at some point, will become more active on some of these issues over the next few years. I'm hoping our clinic will have some role in that, but that's something very much to keep track of.
Great. Well, it is a little past 1:30, so Professor Dinerstein, I want to thank you one more time for such a great presentation, and thank you to everyone who joined us today. Please join us again in August and going forward for more of these free webinars on human rights for legal aid. Thanks again.
Great. Thank you, Lauren, and thank you all for participating.